Occasionally, people create a trust during their lifetimes and fail to properly fund it. And what does funding mean? Essentially, funding is retitling assets that you have into the name of the trust. So with real estate, that is preparing a new deed and filing with the county. With bank accounts, it is often bringing in the certification of trust, which you should get along with the trust, to the bank account, closing those accounts out, opening up an account in the name of the trust. And for all assets that should be funded into the trust, often this is advisable. Your case may be different. There may be reasons why your attorney doesn't want certain assets in a trust, but for the most part, we want all the assets that you have individually, other than retirement type accounts, in the name of the trust. But what happens if a bank account or a stock account or something is held outside of the trust at your death? In Oregon, we are able to do something called a simple estate affidavit, and that is still part of the court process, but it is a much simpler, quicker version than a full-blown probate. Prior to last year, in 2024, we actually had to do a full-blown probate for any asset held outside the trust worth more than $75,000 or $200,000 of real estate. And this was a giant bummer because we have gone through the expense and the time and the effort of creating a trust and mostly funding a trust just to find out after somebody passes away that there's still this asset held outside the trust. The Simple Estate Affidavit has been wonderful in the sense that we now no longer have to do a full-blown probate so long as the less than $75,000 is directed to something other than the trust. So for example, if we still have a gift of, $1 million going to somebody in a will outside the trust, then that would have to be probated. But if everything or most everything is redirected into the trust, then this simple estate affidavit is sufficient. Essentially, with a simple estate affidavit, we have to wait 30 days from the date of death in order to file it, just to ensure that there's no other probates being initiated for any reason. We fill out the simple estate affidavit. You can do it online or with an attorney and submit that to court along with the filing fee. We should still give notice to everybody that's involved. The simple estate requires that, and the state. But we are able to access the funds, or the personal representative, trustee in most cases, is able to access the funds to put it into the trust pretty soon after we file. So the great news with that is we're able to get that asset moved into the trust. The trust still directs where those assets go at the conclusion of the trust administration. Much simpler and smoother. We're still able to use these simple estate affidavits without a trust for smaller estates with that same kind of gift limit of the 75,000, 200,000. So it's 75,000 in personal property, cash assets, that kind of stuff, 200,000 in real estate.